The first case in the morning is State Police Quarterman. Each part about 15 minutes to present their argument. Counsel, how long would you like to reserve?
Thank you, Your Honor. I'm going to reserve 3 minutes.
3 minutes, very good. You know what the good chief, the argument, the time is kept over there, you're the top circle there. I won't use the bottom one, so when your time is at 3, that will be when your time is up. I'll try to let you know when you have about a minute left to give you a reminder at that point in time. I'll try to do the same for you when we get to your point. You know the argument is being recorded, so please make sure when you come to the podium, introduce yourself, stay behind the podium because we're visually recording you, and that will help us pick up your audio as well as you're behind the podium with your microphone. You should not use the name of a child or minor or victim, as you know. Use initials or some other designation, if you would, please. We've read your briefs and are ready to proceed whenever you are.
Thank you, Judge Stevenson. Judge Carr, Judge Stevenson, Judge Lancer. May it please the court, I am Richard Kudici. I am court-appointed counsel for Mr. Quarterman. This is a serious matter. Certainly, it is a murder case. There are too many trial issues that have been identified in the record. Mr. Quarterman, Alexander did not receive a fair trial as a result of that. So, starting with when does the court's comment really rise to the level where it's coloring the jury or coloring the purpose and process of the trial? Lester Johnson, the victim, he went to a men in park with his uncle, the victim. The man in the white shirt came in, there was some conversation. The man in the black shirt came in, there's a red Jeep in the park. The red Jeep, that's the big issue here. The victim struck one of the defendants, some beef arose, and then back and forth the altercation occurs. The 2 named defendants left, but my client forgot his phone, went back in there and got his phone. The red Jeep left. The factual basis is rather simple, but the complexities follow because the next claim is by the nephew that he saw a lot of things going on. He claims he saw a red Jeep going into Mr. Pantry where the victim was. The claim is that the red Jeep struck the victim and then someone, and convicted my client, shot the victim. So that critical point is right there. We have a shooting, we have a vehicle colliding, we have 2 separate claims in the indictment that, in my opinion, merge, as I'll talk about here in a moment. So let's talk about the witness, Shauna. She was one that had a number of problems, failure, recollection, and confusion, but the state was clear in saying they didn't prepare this witness. Now, I'm not here to diss my colleagues, because all of them are all qualified, but with not preparing your witness and then complaining about that and saying, well, we're surprised, that doesn't follow. It's your obligation as trial counsel. You're all trial judges from before. You know that it's required. And in this case, the government did not do what it needed to. The prosecutors did not do what they needed to do. The state had no conversation with your key witness. Now, this person is so important because that person loaned the car, that person owned the car, and that person said there was no damage to the car. And that is critical. And having said that, all of a sudden there's all this debate back and forth. There's disruption in the process, disruption in the jury. There's disruption in the continuity that the jury is watching. So all of a sudden, and you all know as trial judges from before, it is very cautious and careful what the court says in the context of a jury trial. And I am in no way here to diss or criticize the court, but making a statement to the jury that, hey, we're going to recess so this witness can go refresh her recollection, that implies clearly an opinion of credibility, lying, or a need to refresh. So that colors. Now, you may say to me, crew chief, you need to demonstrate prejudice. It is inherent prejudice if you look at everything, the disruption, if you look at the nature of what was going on, the breaks back and forth, the comments, and most importantly, the testimony of this witness. If the state wasn't prepared, they didn't like it, too bad.
How is that set up on the record, though? Typically, when you're refreshing recollection, you say, the witness first has to forget, and then you say, when looking at a video, refresh your recollection. Did that happen on the record before the judge made this comment to the jury?
No, Judge Lynch, I don't believe it did happen, because what do you do when you refresh recollection? Well, you say, here's a document, here's a report, did you say, not a video, so we're gonna look at a video, and
Can anything be used to refresh recollection?
probably,
Anything at all?
probably indeed, probably a report, where you can hand a piece of paper, but you don't say, when you're taking a break in the context of this jury issue, that, hey, we're gonna take a break so this witness can go, change her testimony, maybe find out. The importance in the comment of the court to the jury in the big context of this component of this jury trial.
So in terms of prejudice, after the witness viewed the video, did the witness get back on the stand, and then did the prosecutor say, he had a chance to view this video, did it refresh your recollection about X?
Yeah, thank you for that, because that's exactly, that did not happen. The context of what took place to do this refreshment and how it played out was really incongruous to the disruption. And so that
So you're
was...
saying there's a disruption without a follow-up?
Exactly, and that's what's critical here, and that is concerning to me. So if you're saying to me, well, Richard, where's your prejudice? I ask you to look at the total picture, the disruption, look at the breakups, look at the incongruity, look at how it played out, and look at what unfortunately was said by the court. I'm sure the court had no meaning for this, but I think it had, in my opinion. And in conclusion of this piece, don't have, I have a trial on starting Friday. If I don't interview the witnesses, then it's on me. And my colleagues are very experienced prosecutors. I'm astounded, actually, they didn't have this conversation with this meeting with this person. So to have surprise, recollection, refreshment, all of these things, should it be the court's witness? This was a mistrial, and it should have been declared. The court committed reversible error in those remarks, and if you look at the big picture, the prejudice attaches to the method and the nature. Now, in terms of consecutive sentences, look, the rules apply. So we have to demonstrate in the findings there's necessary need for protection of the public. And the sentence is not proportionate. And we also must look at the foundation for defining consecutive sentences. Look, there's a rule book that has to be followed. And here in this record, there's no foundation for consecutive sentences. It's plain error without judicial fact-finding. Now, I understand what the state is saying here. Well, you don't need to verbatim fact-finding, and you can just put in a judgment entry. No. You all know, I'm sure from your experiences on the trial bench, oftentimes the language in a judgment entry is boilerplate, and that the court secretary might write that. What is required by law is that it be in the hearing transcript and in the journal entry. Particularly, we also look at presumptions.
So wouldn't we just, if it's not in the journal entry, reverse for a non-protunct if it is in the sentencing transcript?
Well, in this instance, even if it is in the judgment entry, it was not in the sentencing hearing, because what's critical here is there was no PSR. Now, how do we come up with a conclusion of danger of history without a pre-sentence report? It's astounding to me, and most importantly, concerning to me, because to go with consecutive sentences, the rule requires 292914C did the court make the proper findings? No, the court did not. But the court said, we're gonna follow the state's recommendation, but yet there's no recitation, there's no colloquy, there's no allocution by the state as to what the prior record was. And then we look at the co-defendant. Well, the court says, well, there was a $50 offense or something from before, we don't know the factual basis of that. You're a little different from the co-defendant. There should not have been disparity, there should not be consecutive sentences. The record does not support that. If you look at the 2928-14C4, that rule requires the findings are not appropriate for consecutive. There's nothing to demonstrate the need for protection for society as a result of history, contrasting to the co-defendant. So the disparity there is plain. In terms of allied offenses, you know, we often have that. So what the state wants to say is, well, you know, we have a felonious assault because you used the car to harm this person, and then somebody else got out and shot. Is there really a difference in trying to kill someone with the car, trying to kill someone? The animus is the same. The behavior is the same. This is plain error. Multiple sentences for allied offenses of similar import are equate to plain error. And by the way, just going back there, I have a citation in my brief as to requiring a judgment entry and the hearing to be particularly defined. These offenses are clearly similar, hit to kill, shoot to kill. What's the difference for purposes of sentencing?
Well, the judge did merge one felonious assault into murder, but not the other involving the vehicle.
That is
So
correct.
Doesn't that imply, or at least maybe express, that the record would show us that the court did an allied offense analysis?
About a minute left, Mr. Kikuchi, if you have to answer Judge Lansing's question, you have about a minute left in your time.
You know, the distinction of how that argument was made, but here we are today to take a review, because this court takes a review of that, and most particularly, if you look at the conduct, the animus, the import. What is import? That is the meaning or the significance of the behavior. They are so much the same, and they are not distinctive. These are allied offenses, and there should not have been a sentence. Count 3 is an attempt to kill. It's not physical harm. And in this instance, they should have been merged, and I think it wasn't fair to not do so, and that's what we need to look at here today on review.
Thank you, Mr. Kikuchi.
Thank you, sir.
May it please the court, Helen DiMartino, on behalf of the state of Ohio, the appellee, we are asking that this court confirm Mr. Quarterman's convictions for felonious assault and murder, as well as the consecutive sentence that was imposed by the trial court. With regard to the second assignment of error in response to the argument made today on behalf of Mr. Quarterman, first of all, with regard to the statements by Ms. Proctor and the idea of refreshing the recollection, that was the court's suggestion, and as acknowledged in appellant's brief, the parties agreed that that was the way they were going to handle it. So first, the witness testified she did not recall when they made the exchange to get the Jeep back. So she had lent her nephew the Jeep that they believe was used in the crime. And then the prosecutor asked the witness, was there any fresh damage when you got the vehicle back? She said no. She had previously indicated yes in a recorded statement to the police. There was a sidebar. The prosecutor asked to treat the witness as hostile, that she was testifying differently than they expected. Contrary to what is being argued today by opposing counsel, the record does not reflect that the prosecution did not make efforts to interview this witness. There really isn't anything that I recall in the record as far as whether there was or was not an interview or what efforts were made to talk to that witness. What it reflects is that the prosecutor said, I did not know how she was going to testify today. And to be honest, that's true in every case. We never know how someone is going to testify. We
Well,
prep witnesses.
Yes, but there has to be some standard of due diligence. I mean, some kind of
Correct.
reasonableness.
But there was,
And I was just gonna say, I read, I'm sorry.
no, you're fine, it's me, it's old age.
I've got the same problem. Anyway, but I read in somebody's brief, it's probably Helen's brief, that the prosecutor said he had talked to the witness on the phone. So obviously, he at least had some communication. with
Correct. There was some indication in the record that there was communication with that witness, and there certainly was, as raised by the appellant, in response to the argument that we were surprised at how the witness testified, there was a statement made that the witness had given multiple versions of the event, so how could we be surprised? So there was never anything raised in the trial court that would be preserved as far as.
I think the problem is, isn't the problem that we're talking about refreshing recollection instead of impeachment, right?
Correct.
Basically, she did give testimony about an event, and then it turns into, well,
Correct.
We need to refresh your recollection. It's not, was that part of it improper?
It was not raised in the trial court below, so it was not preserved. They in fact agreed to go ahead and handle it with going back and asking the witness to listen to the tape and see if it refreshed a recollection. So yes, it was not raised in the trial court as an impeachment. You know, we did not ask to impeach the witness.
Because normally, if there's a prior inconsistent statement, that's when you cross-examine on a prior.
Exactly. So it was not handled that way, and it was not preserved as error either.
So,
I'm sorry.
so then it looks like the court is saying your testimony is not correct, and we're gonna refresh your recollection. I think that's the issue here, right?
So the issue is, so I just wanted to clear that up, because what was argued today is not what is raised in the brief. The issue that was raised at the trial court and in the brief is that the statement that was made to the jury by the court, which said we're gonna take a break so we can refresh the recollection of this witness with a video, that was the entire thing that was raised. And the state is arguing that just saying we're gonna refresh recollection with a video does not imply that the court is saying that the witness lied or that the witness is credible. The cases that are cited are mostly going to, did that single statement bolster the credibility, or did the court some way?
But isn't it an implication if the witness never said she didn't remember or needed her recollection refreshed?
I think as lawyers, we are looking into it to say, why would someone need to have why would they need to have something refreshed? What is the reason for it? But I don't think that a jury is going to look at it and say, okay, we're gonna refresh somebody's recollection with a video. It's not even known to them what the video is. Is it a video of Ms. Proctor giving a statement? What is the video of? It was never put into the record.
You're saying it's a neutral statement.
I believe it's a neutral statement, and I think the court was in fact just trying to explain why we're taking a break, and I don't think that there's any indication that the jury thought anything of it other than we're taking a break, and here's the explanation why.
And that's what I was gonna ask you, some of the questions that Judge Lanzinger did, but I wanted to ask again for clarification purposes. I know the defense attorney moved for a mistrial.
Correct.
Did the prosecution give any reason why it was not a mistrial?
I believe that the response, yes, but I believe the response was that it didn't rise to the level of a mistrial and went through those elements.
But the prosecution did agree that the judge should not have said that.
The prosecution said that they believed the statement essentially was neutral, that it was not, it was just an explanation to give the break, and that it was, we didn't really take a position on, other than that it was neutral.
When the break was over and the witness was still on the stand, or put back on the stand, whatever happened there, I didn't understand completely the process or what happened, what the record reflects. Did they ask the witness about anything, and did she change her testimony?
I don't recall that she changed her testimony, and I don't recall that they went back and asked her about the damage again, to be honest.
So, just like Mr. Kudici said then, it was just a matter of everybody just let it slide.
Correct.
Doesn't that kind of hurt your position too, because of the fact that if the prosecutor didn't even, try to ask the witness about the damage again, then an argument could be made that she just wasn't believable, and the judge is like, because isn't it, see, I guess the issue I'm having is a little bit different than, like Judge Lanzinger asked about, giving somebody a document, says, is this refresh recollection, they say they don't know, whatever. But when a judge says something, front of the jury. They're supposed to listen to the judge.
Correct.
So isn't that a little bit different here?
I don't, like I said, I don't think that the jury took, we're gonna refresh a recollection with the video to mean anything. I don't think
But
that,
we don't know.
right, we don't know, and there's nothing, and it's his burden to show prejudice, and that is not in the record. So I don't believe that coming back in and then the court proceeding the way that it did, what the state was seeking was to treat the victim, the witness as a hostile witness. And because the parties agreed to go ahead and refresh the recollection, when we came back in, that's the way that it was handled. So it does not read the way you would expect an attempt to refresh a recollection, because that wasn't what was asked for. And it doesn't also read the record like a situation where you're asking for a hostile witness, because it kind of got conflated by the way that the court handled it and the parties agreed to it. So while it's not perfect, I don't believe that it rises to error. And if it was error, it would be harmless error in this situation due to the overwhelming amount of evidence and the defendant's failure to meet the burden of proving that that single statement caused prejudice and would have caused a different result if the court had said something else. So moving on to, if there are no other questions on that, moving on to the issues with regard to sentencing, which is, I believe, what the appellant went to next. In this case, there were 4 charges. The first was purposeful murder. The second was causing murder while, attempting to cause or causing physical harm through the use of a deadly weapon or dangerous ordinance. Then there was a felonious assault using a motor vehicle and felonious assault using a firearm. The first 3 charges merged, which were the purposeful murder, the murder while committing the motor vehicle attempt, a felonious assault, and then that left the 4th charge, which was the felonious assault using a deadly weapon. The state would argue that there is clearly separate animus when you're using a motor vehicle versus a firearm. 1. 2, it was 2 different people that committed the act. So it would be very difficult to conflate the animus of Mr. Fowler and Mr. Quarterman in the 2 separate actions that they took. There's no dispute or no argument raised by the appellant that it was Mr. Fowler who was driving the vehicle and struck the victim, and then it was Mr. Quarterman who then fired the shot. Earlier in the record, the nephew, Mr. Johnson, had testified that when the 2 defendants left the mini mart, Mr. Quarterman came back to his phone and he said to Mr. Johnson that he'll get him. So that would be consistent with Mr. Fowler striking the decedent with the vehicle with the intent to cause some physical harm using a deadly weapon, being the motor vehicle, so that with a separate animus, his co-defendant, Mr. Quarterman, could shoot and kill him and do just as he said he would, which is to get him. So the record shows that there was an allied import analysis and that the court found that the felonious assault using the motor vehicle committed by a different person was done with a separate animus from the felonious assault using the firearm, which again was done by Mr. Quarterman as opposed to Mr. Fowler. The state would also argue that the record shows all of the required elements under 2914C4 for consecutive sentences. The court, at the initial commencement of the sentencing hearing, did talk about the fact that there are 2 co-defendants. Mr. Quarterman's record is more serious than Mr. Fowler's. The court noted that there were violent history on Mr. Quarterman's behalf. The court indicated on page 25 and 26 that Mr. Quarterman's history was different. He had a history of violent convictions, and that those convictions necessitate consecutive sentences to protect the public, which are the elements that are required for consecutive sentences. The idea that you have to have a PSI for a court to determine whether or not someone poses a danger to the public is not supported by statute or by
Did the court
case law.
indicate where it was getting its record from, since there's no PSI?
The court did not, just indicated the long history. And the defendant doesn't refute or dispute that he has a long history or that he has a violent history. So that would be presumed to be correct in the record and would support the basis for the findings which are required by the statute. With regard to the first assignment of error, which was not addressed here, the state would argue that the videos were properly authenticated under Evidence Rule 901, which allows someone with knowledge to testify that the item, the video, is basically what it is claimed to be. One of the videos that's included in assignment of error 1 was Officer Phillips' body-worn camera, which was not objected to at the trial court. With regard to the mini-mart videos and the City of Akron video that captured what happened as far as the incident with the Jeep striking the victim and then Mr. Quarterman shooting the victim, those videos were properly obtained. Law enforcement testified with regard to that they received them from the mini-mart and from the City of Akron. Mr. Johnson testified that he heard and saw everything contained on those videos in real time. While he didn't see the initial scuffle that started with Mr. Fowler and his uncle, he did hear it, and he did testify to seeing the two men enter the mini-mart. He described what they were wearing. He talked about once the scuffle started, he intervened. He felt what he believed to be a gun on Mr. Quarterman. He talked about the two men leaving in the red Jeep. He then later saw the red Jeep strike his uncle. So all of the things that are on the video were authenticated by this witness, Mr. Johnson. And as far as what's on the video and whether they match what Mr. Johnson said, those would be issues of weight and credibility for the jury to then determine. But the videos were properly authenticated under Evidence Rule 901.
Is there an issue with the timing of the objection to authentication? It sounded like in the brief that the objection wasn't made till the close of the prosecution's case. Is
That's
that an
also-
issue here?
I would argue that that is also an issue because the videos were played. The jury already saw all the videos. There was cross-examination based on the videos. So they should have, any objection should have been raised with regard to authentication at the time that the videos were played. So based on the record and the arguments contained in my brief, we would ask that this court confirm Mr. Quarterman's convictions for murder and felonious assault, as well as the consecutive sentence imposed by the trial court. Thank you.
Thank you, Attorney Martino. Ms. Guccia?
Thank you. Listen, the rules are the rules. Now, I'm all about, let's extend the rules a little bit, let's be a little mushy with the rules. If the defendant, if the defendant would have put on a video without authenticating it, so I can't just hear, well, somebody said it was okay, someone was said, look, that's what I saw. That's not what authentication is about. The rules require, because those could have been altered, or they might not have been appropriately brought, focused in. You know, there's a number of things, and that's what the rules are important for. You know, in regard to the comments by the bottom line is, and clearly it's fine, the state did not like that testimony. Now, its testimony is what it is. It's not just something that we're going to create, put a witness on, that's what the witness says, and that's that. I clearly raised these issues in the appellate brief. You know, it doesn't really matter what occurred in the process. What matters is what the judge, the court said, not what the court's intent was. It is certainly not harmless when you look at the totality of what was going on. A witness should testify, say what it is, and that's that. In terms of the process, we've already gone over that in my initial remarks. When you look at the separate animus, and the state raised something clear. This is a complicity case. Well, the complicity was apparently to kill the victim. Hence, if you're going to kill the victim with a car, you're going to kill the victim with a gun. The intent to kill, it wasn't an intent to cause serious physical harm. That's what both of these defendants were convicted on.
But when we're talking about element offenses, we're talking about facts of the offense, aren't we? Isn't it a factual, not just the intent portion of that?
It is indeed. And if you look at the various elements that are required in that, it has to do with the animus. It has to do with, yes, the conduct. And that conduct precisely was the same for both of those things. And that's why it is critical when you examine the intent to merge trying to hurt someone, trying to kill someone. No one's saying who's and either one of these complicit individuals, as claimed, was trying to hurt. They were trying to kill this person. That's why the offenses should merge. In conclusion, we need to look at what's fair, and in this case, if you look at the big picture, Alexander Quarterman did not receive a fair trial because of these issues, because of the mistrial, because of what went on in the disjunctive nature. The fact that these lawyers did not object, I didn't raise that issue, and on, ineffective assistance, we all know what that's all about. That can be a post-conviction relief issue. Your Honors, in this case needs to go back for a trial that is operated smoothly and fairly. Thank you for hearing me on behalf of Alexander.
Thank you. And thank both of you for your presentation today on behalf of the court. The court will take the matter of advisement and issue a decision in due course. When that decision is released, it will be mailed to you by the clerk of court's office and also posted on the